One, when I say I'm struck listening to the previous talks, but this is something I have a general interest in, and that is that I think that many academics, whether they're lawyers or social scientists who write about law, don't understand judges, including Supreme Court justices. Or, especially if they're law professors, they do understand, but they think it would be impolitic to speak frankly about judges. And this it's very important, however, that you be realistic about judges, because otherwise you won't know how to communicate with them and make your empirical findings usable by judges. So the way in which the academic, whether lawyer or social scientist, talks about judges, whether they believe it or not, is that they think of judges as being like academics. They're looking for correct answers to questions that arise in cases. They differ only in that they're not as smart as academics. We know they're not as smart because merit plays such a smaller role in judicial selection than in academic selection. There are hundreds, perhaps even thousands, of American lawyers who would be abler Supreme Court justices than the current 9 justices. Ability is only one consideration in appointing a judge, and it's by no means the most important one, especially in the Supreme Court, where the appointment of a Supreme Court justice is a big thing for the president. And what the president gets from that is not getting the best person for the job, but getting someone who has maybe the right race, sex, what have you, right political views. Now, of particular reference to this conference, not only is the fact that the Supreme Court is not really outstanding, but none of the justices has any empirical, technical background. They're just humanities majors. So, but there's something more fundamental in the difference between academics and judges. The academics tackle questions that they think they can answer. They pick their topics. And, with a view toward the feasibility of making progress on a particular topic. But the judges make decisions in cases that come at them randomly. So the judge's duty is to decide, even if the judge has no idea what a correct, sensible decision would be in a case, or a decision congenial to the judge's views. The duty to decide is fundamental. And that makes a tremendous difference to how one thinks about problems and what one brings to the problems. There's a large area in federal law that I call the open area, where there are really no guideposts. And in these areas, the judges fall back on their priors, often unconscious. But they include, politics, ideology, ambition, for example. The judges who are angling for promotion. District judges to become Court of Appeals judges. Some Court of Appeals judges really think they have a chance at the Supreme Court, and they try to decide cases accordingly. Some are looking for posthumous fame. And of course, people's race, gender, temperament, background of both personal and career and personality. Temperament, very important. Some judges have there's a literature on the authoritarian personality, psychological literature. Some judges are very authoritarian. They get very indignant at criminals and sentence them to very long terms because they just don't understand, what might make a person a criminal. Now, all this has been known for an awfully long time. So Holmes said 133 years ago, said the life of the law has not been logic, it has been experienced. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. And that's as true today as it was in 1881, and it's true if we substitute regression analysis for syllogism. So judges are influenced to a degree by facts, but of course only facts they understand. And they don't know how to evaluate statistical or otherwise systematic empirical work. Or to be more precise, more relevant, we I should say, don't know how to extract fact or truth from social scientific research. As a result, they do mention it in opinions, but they're not really using it or relying on it. So as you probably know, though judges tend to be coy about this, almost all judicial opinions nowadays are written by law clerks. And that's true on the Supreme Court. All the justices have their law clerks write the first draft of the opinion. And how much editing there is by judges or justices varies with the judge or justice. Often there's very little. Some of them have one clerk edit the other law clerk's draft. Some of them require that the law clerks agree on the opinion and present it to the justice, so he or she can be confident that it must be right. So now the law clerk, for the law clerk, writing an opinion means writing a brief in support of the judge's vote. So the law clerks will be happy to cite empirical literature if it supports the judge's vote. Doesn't mean they believe it or have any opinion about it, but if it looks reputable, we'll go in. The materials on the other side will not, however, the contrary findings that will be left to the opponent to find if they can. So I think it's, you have to be very careful to try to determine whether the use of empirical work in judicial opinions is more than rhetorical. Maybe when you write about judicial opinions, instead of saying the judge relied on or used or something, some study, you should just say the judge's opinion cited a study. Now, I want to take issue with something Jeff said today about the Supreme Court having made a mistake in Brown versus Board of Education in citing Kenneth Clark's doll study, which showed that black children prefer white to black dolls. Well, I don't think it was a mistake, because the problem for the Supreme Court and Brown versus Board of Education was that they wanted, of course, to invalidate public school segregation for quite obvious reasons. But they wanted to do it without insulting the white Southerners. I'm sure they were told by Justice Black, you mustn't say anything critical of Southerners, because otherwise you're going to have a lot of unrest and defiance in the South which of course occurred. But the idea was not to say anything about the motives for segregated schools, but just to point out, using the Dahl study, that, it had just been discovered, wasn't the fault of the Southerners, they didn't know Kenneth Clark, that empirical evidence had shown that segregation had bad consequences for the black children. So whether the justices or their law clerks knew that the study was flawed or cared, probably didn't care. They had very, very different motives, and I'm sure often the empirical evidence recited in an opinion has nothing to do with the decision. I think another example of that, I think there are many, but Roper versus Simmons is a Supreme Court case that held that you can't execute minors. And I'm sure the reason that they just thought it was, kind of doesn't look nice to be executing children. But instead, I think the Kennedy opinion has reams of dubious material about psychological maturation of children. Actually, it's pretty clear from the material, some of which they cite, some of which they don't cite, that you can't just say age 18, the one's under it, or immature, the one's over it. It's not like that at all. But again, it goes back, there's a Yiddish joke that I enjoy and think very applicable to the judiciary, that some guy in some shtetl community in 19th century Russia, and he's walking along and he sees that the mohel, does the ritual circumcisions, has a new I don't know, shop or place of business, I don't know what you call it. And it's new, it's fancy, it's actually got a show window. And he notices that in the show window there are a bunch of watches being exhibited. So he's puzzled by this. So he goes in and he says to Moyle, I don't understand, I mean, nice new shop and your show window and everything, but I don't understand why you're exhibiting watches when you are a mohel. And so the mohel says, what do you want me to put in the show window? So that, I think, that's the judicial problem. The judges are shy about saying why they're doing things, and they'll be happy to hide behind empirical evidence without any real concern with whether it's truthful or... Now, I think it's important to distinguish among types of empirical evidence and how they should be presented to judges, what can be done for the judges. There are a lot of continuing educational programs for judges, and it's very difficult to do, though, because the problem is, again, it's the unpredictability of the judicial workload, judicial caseload. If a judge takes a 2-week course in, regression analysis, say, it may be a year before he sees a case in which someone wants him to give some attention to regression analysis, and then he's forgotten it all. So it's very, very hard. But one thing that came up this morning was the neutral experts. So, published academic or otherwise, professional products by competent people, they're certainly proper to consider. But invariably, in complex cases, there are party-appointed expert witnesses. They're sometimes called by lawyers paid liars. And they will battle each other, testifying before the judge or jury. And It was remarked this morning that often, if it's a jury, it could be true of the judge. The tendency often is to simply consider them to cancel each other out and find some other ground for the decision. But even though judges clearly have the authority, federal judges clearly have the authority to appoint their own expert, this is done extremely rarely because of the commitment that most judges feel to the adversary system. The notion somehow truth is produced by a couple of self-interested lawyers with very low standards of candor and highly paid experts, and somehow this generates truth before an audience of ignoramuses, the jury and the judge. So you really need to have a neutral. So I do patent cases as a volunteer in the district court, and I ask the parties to have their experts get together and nominate some 2 or 3 neutrals, and then I interview them and appoint one. And you get an academic who's very, very good at explaining things because he's had elementary students, and someone like that can be extremely valuable. And I can tell a jury that, look, first expert you're going to hear from is the expert that I appointed, and he was nominated by the party's expert, so they accept that he's a neutral, and he's highly qualified, and his fee is being split between the litigants, and I've told them they can't question his fee. So you'll want to listen very carefully to him. Then you'll hear the party experts. So, but I say, very, very, very few judges do anything like this. Another source of expert evidence that's quite unreliable are the amicus curiae briefs. And there's been criticism for the Supreme Court having gullibly accepted empirical assertions in amicus curiae briefs. Now, with the neutral expert, there's an issue both of reliability, accuracy, neutrality, but there's also a big issue of communication. And what's good about professors who teach elementary classes is that they know how to. I interviewed one expert. I think it was a party expert, and I'm not sure why I was interviewing him, but I was. And I think it was about, DNA or something complicated. And I asked him whether he had any experience, whether he thought he could explain his views to a lay audience. Jurors, they wouldn't have any technical background, in all likelihood, maybe one would. And he said, oh yes, because I teach a little course at Disneyland, and I explain this to the kids and the tourists. So I said, yeah, you're perfect, right? So the judges really have to be, if they're dealing with a jury, they have to make sure that any findings, statistical, what have you, are made very, very clear, with the kind of visual aids which you've seen. A simple graph, a simple table will do a lot. And that should be to doable. But again, the judges have to be alert to the limitations of their audience. The problem is that the empirical work, however convincing it is, it's often going to come into collision with the judge's political or other feelings about a case. It's very easy for judges to brush aside persuasive evidence by just saying, well, that's not how I feel about it, you know. So, so I don't quite know how that can be overcome. There are some areas where I think science and social science, natural science can have an influence. There are areas in which the judges don't really have strong priors. So patent law is an example of that. There used to be fierce controversy on the Supreme Court among the justices like Justice Douglas, who hated the patent system and couldn't really distinguish between good monopoly and bad monopoly, and the more conservative justices. But now I think there isn't that kind of division on the Supreme Court. And they, I think, are willing to listen within the degree of their understanding. Now, my guess is that the law clerks have a big effect, because often, you know, these Supreme Court justices have 4 law clerks. Often, if they're smart, they'll hire at least 1 or 2 who have good technical backgrounds. And often they will have at least 1, and that'll make a big difference. So, what can be done in legal education to improve communication between social scientists and the judges? As I say, I don't think too much can be done with the judges themselves, but a lot can be done with students. I think there's too much law taught in law schools. I think academic lawyers, in fact, lawyers generally, exaggerate the importance of legal doctrine, precedent, and so on. I think in a very large number of cases, the judges are just, they're trying to reach a result which is reasonable according to their lights, and they're not critically interested in doctrine and precedent. You know, what's a reasonable result? And they're very interested in the facts, because that's going to determine what is a reasonable result. And if the social scientists, natural scientists are to communicate facts in a way intelligible to judges, they have to understand the limitations of judicial intelligence and understanding, and how it is that results of academic studies can be rendered basically in words of 1 syllable for the judge. And I don't know whether law schools think of this as something which is one of their responsibilities. Make the students who have no technical background take technical courses while they're in law school. They don't have to take 3 years just of law courses. There's plenty of time for other stuff. So a traditional problem, remember when accounting used to be a compulsory course when I was a law student. Well, if it's compulsory, then you're going to get some people in the course who don't need it. The problem is if it's an elective course, the students who need the say accounting the most will not take it, because they feel they will be outclassed by the ones who know accounting, who will take the course because it'll be a gut for them. So I think law schools should require people who do not have a technical background to devote, a significant chunk, not 50%, but a chunk of their time in law school to taking courses, not necessarily in the law school, in areas that are, very important. Accounting happens to be a very important area, finance. Biological evidence, like DNA, medical, common medical problems that arise in law, statistics, certainly, psychology, economics. They're going to get a lot of economic analysis in their regular law courses. And I think the law students have to be taught how to communicate with judges, how to deal with facts. I noticed that moot courts, I don't know if it's true here, they tend to have very artificial fact records on which the oral arguments are based, the briefs and oral argument. That's a mistake, because the most important thing for the advocate is to use the facts in a persuasive way. It has to understand them and look outside the record. And I think the faculty should make sure that the moot court does that and isn't just abstract doctrinal stuff. I think those are. I think I had one more point I wanted to make, but I forgot it. So I'll stop.
Question?
Yes.
Given this sort of view of judges, and one of the frequent proposals is to have more specialized courts, where you really do select people. I mean, Federal Circuit would be the classic example when talking about patents. But what do you think about that, and which areas of law do you think it's?
Well, for some reason, specialized courts do not work in the federal system. So I don't know anything about, juvenile courts and divorce courts and so on in the states. The Federal Circuit is the worst court in the United States. The Social Security Administration is, with its administrative law judges, that's a specialized court, it's terrible. The Immigration Court is unspeakable. So somehow we have a very bad history with specialized federal courts. And you can see also why it's not going to work well. The specialists, they will develop a special vocabulary which will be unintelligible to anybody else. And it'll make review by the Supreme Court, for example, if you're going to have at least a generalist court at the top, very difficult, because they just, they sink into their jargon. The other point I was going to make, it has to do with something I get a lot of criticism for, which I ignore completely, and that is it was given a name, independent, I'd never heard this before, independent judicial research, which means the judge is doing their own factual research, usually on the web. And I do it because if the lawyers aren't going to give me the facts that I think I need to decide a case intelligently, I will try to find them myself. I try to use reputable sources. Probably doesn't always work, but for example, all of the major hospital chains or hospitals, great medical institutions like the Cleveland Clinic, the Mayo Clinic, Sloan Kettering, the Centers for Disease Control and Protection, which used to be a well-regarded organization. They have great websites, and they're very reputable. But there are all sorts of resources on the web. So people say, well, you're not subjecting it to the adversary process. You're finding facts. You're doing appellate fact. One of my colleagues criticized me in a case for appellate fact finding. It's apparently forbidden. But the criticisms rest on the fiction that the adversary process is a effective way of generating truth, which obviously isn't true, because when you look at the very limited capacities of the jurors and the judges and the incentives of the lawyers and of the witnesses, you forget about it, expert witnesses. Do ordinary witnesses tell the truth? Not if they're a party. The olden days, right, parties couldn't testify because they were biased. They're still biased. They're now allowed to testify. And the psychologists have ridiculed many of the assumptions on which our adversary process rests. Eyewitness testimony, which used to be regarded as the gold standard of testimony, has been shown to be extraordinarily inaccurate. And, some of the rules of evidence about excited utterance, and they have shown to be not the notion that if you say something when you're excited or fearful, it's going to be the truth, that there are no spontaneous lies. That is a federal rule of procedure, and it is false. So I think independent judicial research is important. The hope is that it would make the lawyers more resourceful about using the web as a source of facts rather than depositions and so on. So, and of course, it's on the web that the judge, the law clerk, will find a lot of academic research, and the problem will be a translation problem. Yes.
So law schools get a lot of feedback from law firms about what we should be training our students to do. Presumably the lawyers in these firms have some experience, with what works for them. You don't hear this, right? They say, oh, we want more practical training in the law, I don't think I've ever heard a lawyer from some alumni group come in and say, you need to be teaching your students how to talk about statistics to judges or anything. Well, why is
that? The quality of the legal advocacy in our court, my court, is extremely low, and even from good firms. And I think the problem is that goes back to the first thing I said. They don't understand judges. They don't understand the judicial mentality. They don't tell us the most obvious things that a normal person would think about in a particular type of case, like the age of the victim. I mean, suppose you have a prisoner, and he's complaining about prison conditions, savage prison conditions. Well, you might think it would make a difference if he was 21, if he was 70 or something. But they're always leaving out these facts. That is, if the judge tries to make a coherent narrative of what and why did this happen and why then and so on, often the facts that you need for that have simply been left out. They're excessively obsessed with, I mean, you look at the first thing in a brief is the list of all the cases they've cited. Pages and pages of citations. Almost all of it completely useless. So they're fussing over trying to extract phrases and made up holdings from cases and not telling us what the facts are. Or they give severely truncated or one-sided. And then you read the two briefs, and you have to go back to the record. Where often, you know, there's nowhere in the record. So sometimes, you know, I had a case, for example. We have this wonderful Telephone Consumer Protection Act, which I hope you're all familiar with. You may make money from it someday. But if you receive an unsolicited fax advertisement, you are entitled to seek statutory damages of, I don't know, about 1,000, may go up to 3,000. Now, you wouldn't bother probably, but you could become part of a class action. So we had a typical Telephone Consumer Protection Act class action in which what's called a fax buster, a company that specializes in distributing fax advertisements, goes to some sucker company which has never heard of the Telephone Consumer Protection Act and says, what you need is like 100,000 faxes. That's a great way of advertising. It's very cheap. So the company says, fine. So the next thing you know, it's hit by this, right, $100 million suit. Because there are 100,000 recipients, presumably none of whom had solicited the advertisement, $100 million. So you go to the defendant and says, well, actually, you know, you're liable to us for $100 million, but we know you don't have $100 million. So if you would give us $5,000, we'll recommend to the judge that he accept this settlement. So in one case where I had this, there was nothing about the defendant. So I looked up the defendant company in Dun & Bradstreet, and it turned out this company, which, I don't know, it sells furniture or something somewhere in California. This company has 2 employees. So the notion of its being the defendant in the $100 million case was wonderfully ludicrous. So you'd think the defendant's brief would say, this is a very little company. We're pathetic. We have 2 employees. We can't, even the settlement they want, we can't do it. And we didn't know anything about it. We'd never heard of the Telephone Consumer Protection Act. An appeal to our mercy would probably be successful. So I don't understand how the lawyers could have left that out of their case. But we are constantly encountering this. Or else it's sort of mindless complexity. We had a case under the Communications Act of 1993 or so, and I read the briefs, and law clerks read the briefs. It was gibberish. It was all technical stuff about communications and also about the Communications Act, which is very complicated. So in the argument, I said to one of the lawyers, I said, look, I read your brief, the briefs, and my law clerks read the briefs, and we don't have the faintest idea about what this case is about. So he was, so could you explain in words of one syllable, what it's about? So this lawyer is a little taken aback. Judges don't usually talk that way. But he did, and he explained it very simply. And it was actually quite a straightforward case. it turns out, of course, that, you know, he and the other lawyers, they appear mainly before the Federal Communications Commission, and they share this technical language with the commissioners. But not to realize that walking into a court which hears maybe one Telecommunications Act case every 5 years, you can't talk that way. And that this was a good lawyer, so they're just not thinking about the limitations of the generalist judiciary. And I don't understand why. It seems so obvious, but that's why I say there's a. Now maybe they feel they're worried that if they talk to us in words of one syllable, we'll be offended. We'll feel we're being patronized. Our omniscience is being questioned. But you know, after the oral argument, we have our post-argument conference. The judges always agree on, you know, which lawyers did a good job. I've never heard a judge say, "Oh, they were talking down to us," or they were, you know, they were trying to explain stuff that we know better than they do. No, never. We're happy to be spoon-fed by the lawyers. Yes.
What did you think of the reference from your court, not in your decision, to a Harvard Law Review article as something that oughtn't be paid attention to because not peer-reviewed?
Yes, that was very funny. Frank, yes, right. Yes, what did I say about that? Well, I mentioned it in my dissent, and I said, so much for law reviews. So,
And for Supreme Court.
oh.
I think you pointed out that other studies had supported it.
Oh yeah, I didn't just cite the Harvard Law Review.
No,
Yeah,
but you
yeah,
responded to Frank's.
yeah. But no, you can't insist on peer review of everything one cites. Obviously, there are reputable factual sources that aren't subject to peer review.
But on the other hand, isn't that a reasonable, so, you know, the amicus, they throw in a lot of stuff, as you know, but wouldn't a peer-reviewed finding be a marker that this was, you know, accepted or at least passed a pretty high bar?
Yes, the only qualification would be that the lawyer would have to explain what does peer review mean, right? You can't just say peer reviewed. You'd have to say, you know, it's sent, maybe the author's name is concealed, something like that, and it's sent to people with recognized reputation in the field.
I'm smiling.
If you explain that, pardon?
I'm smiling because, you know, if Jeff, you might have had this experience when you're in a law school and you have to go before a university committee to defend someone's tenure case, and you know you say, oh, they published in the Harvard Law Review, and they ask, is that peer reviewed? And you say no. Everyone in the room bursts out laughing, right? Because it's exactly the opposite of the rest of the academic world.
Yes.
We don't understand non-peer reviewed stuff, right? But the judges, you have to explain what peer review
Oh yeah,
is.
you have to explain. Yeah.
Can I
Yeah.
just say one thing about that article, which is that it turned out, although no one knows that it was peer reviewed, not
Oh,
in the
really?
acceptance stage, when we submitted it.
Oh, that's
it-
funny.
Jim Greiner checked every one of the statistics, and so as compared to most of the peer reviewed stuff in the field, there was a lot. But Easterbrook is understandably wouldn't know that.
Oh, that's good.
Yeah, what are judges supposed to do when empirical evidence is cited in a brief that seems relevant to the issue in dispute, but they don't really know how to evaluate, you know, the reliability of the data, or even necessarily to understand the data. but it seems like it's appropriate to be there, and it seems like it's, in theory, should be helpful. What are they supposed to do in that situation?
Well, if it's really critical, they could, ask for supplemental briefing, explaining the work and what verification it's received. We can't do that. I can't think of a case where that's happened. I think because I can't think of a case where a lawyer in a brief said, in effect, our case turns on this study.
The lawyers basically don't invoke empirical work.
They may, but not to make it so critical.
Right,
Yeah,
central to
yeah,
it.
that's what I think is very is very rare. They may be thinking that if that it would have been presented at the district court level, and the district court judge accepted it or didn't accept it, and if he accepted it, they'll treat that as gospel, as we have the clearly erroneous standard. If he rejected it, they might try to resuscitate it and say it was, reputable, was peer-reviewed, and so on. But actually, they tend not to place great emphasis on empirical work of any sort. More on expert witness testimony.
On that discouraging note, we should thank Judge Posner.
Okay, thank you very much.